All right, welcome back, everybody. And without any further ado, I'll pass it back to Philip.
Hello, welcome everyone. We got a great speaker coming up, keeping on track with the rest of the awesome speakers we had today. Our next speaker is Kurt Opsahl. He is the Deputy Executive Director and General Counsel for the Electronic Frontier Foundation. In addition to representing clients on civil liberties, free speech, and privacy law, Opsahl counsels on EFFF projects initiatives. He is the lead attorney on the Coders' Rights Project and is representing several companies who are challenging national security laws before joining EFF. He worked at Perkins Coie, where he represented technology clients with respect to intellectual property, privacy, defamation, and other online liability matters, including working on Kelly versus Arabsoft, MGM versus Grokster, and CoStar versus LoopNet for his work responding to government subpoenas. He is proud to be called a rabid dog by the Department of Justice. Prior to Perkins, he was a research fellow to the Professor Pamela Samuelson at UC Berkeley School of Information Management and Systems. He received his law degree from Bolt Hall and undergraduate degree from UC Santa Cruz. He has co-authored Electronic Media and Privacy Law Handbook. In 2007, he was named as the Attorney of the Year by California Lawyer Magazine for his work on O'Grady versus Superior Court appeal. In 2014, he was elected to the Usenex Board of Directors. Thanks, and thanks for joining us today, and look forward to your talk.
Yeah, thank you. Thank you for having me. A pleasure to be here. What a great lineup of folks we have. So yes, so I'm Kurt Opsahl. I'm with the Electronic Frontier Foundation, and I'm here to talk to you about vulnerability research and reporting, trying to give some practical advice, things you should do or try to avoid when you are dealing with a vulnerability. But I'll start off with a little bit to tell you about the EFF and the Coders' Rights Project, some of the legal and policy issues that we're trying to achieve through the Coders' Rights Progress. But mostly this is going to be trying to be at least practical tips, so research tips, and good and bad practices for disclosure. So starting out, what is the EFF? Hopefully many of you are familiar with it, but if not, it is a nonprofit organization founded in 1990. So we've been around. This is last year was our 30th anniversary. And since its founding, EFF has been championing things like privacy, free expression, trying to promote innovation. We use tools like impact litigation with our lawyers, policy and grassroots activism, and we have some technologists who try to make freedom-enhancing software in order to try and find technical solutions for some of our problems. And one of those projects is the Coders' Rights Project. And this is something that EFF has cared about for a long time, trying to help people who are programming, who are doing research, to be able to do that research and build a safer internet. So a lot of people that we work with are security or encryption researchers. Now they're doing great work. You all know this, you know that by finding vulnerabilities, disclosing, talking about them, this enhances security for everybody. But nevertheless, we have had for many years problems where researchers are facing legal threats, legal challenges that may make it harder to do the work that keeps us all safe. So why do we care about vulnerability disclosure? Well, it's the free flow of information and the uninhibited exchange of ideas that this enhances security research by allowing people to obtain knowledge from other people, try to avoid making that problem or making that mistake in the future. It also enhances the overall security, because if a problem is with one company, it may be with another company, and they can fix it before it spreads. We're also big supporters of free expression, the First Amendment, which protects disclosure about security things, including code. Proof of concept code, for example, is often controversial, but I think it is protected by the First Amendment. Now, there's also a lot of talk about what is responsible disclosure. And the thing is that the responsible disclosure, what is responsible, is very dependent on the circumstances. So for example, there may be a circumstance where the most responsible thing to do is to give a vendor plenty of time to solve a vulnerability before you disclose that to the public. And another thing, the vulnerability might be so bad and so difficult to solve that it's more appropriate to warn people away from that product because they're at risk. Maybe it's a exploit being used in the wild. And so an immediate disclosure is appropriate. So how to do disclosure, what is ultimately responsible is going to be so circumstance dependent that we don't want the law to be policing what that is. So a foundational issue for the coders' rights partners is that code is speech. This is something that EFF helped establish in the 1990s, a critical case there, Bernstein versus the United States. This was dealing with an open source encryption code that was accused of violating some sanctions laws for being published on the internet. Because for a while, at least, there was a notion that you could not export strong crypto. So there were import or export crypto and domestic crypto. And if you put strong crypto on the web, they said, well, maybe you're exporting it. And in that case, I have a quote here from Marilyn Hall Patel. This was an early decision in the case that eventually went up to the appeals court. But I like the language here to just show, like, looking at it like it's just a language, it's a way of communicating. Code is a way of communicating the same way that other languages are and should be protected by the same rights. So the project goals, we want to protect vulnerability disclosure. We want to make the world safe for pen testing tools. Oftentimes the same tools that are very useful for penetration testing are the tools that could be used by someone acting in bad faith to hack something. And if you try and ban those tools, you'll ultimately make things less secure. Also, proof of concept code can be very useful, even though it can be used in a bad way. We also are trying on the policy level. We want to discourage overly broad anti-hacking laws. There are many anti-hacking laws. They're often quite severe. They have high penalties. And one of the things that really is a tragedy is when the remote chance that someone might be caught up in a anti-hacking law discourages the research, because you don't want to take a 10% chance of going to jail, even though you're 90% likely it's going to be fine. Because the penalties are so severe. Also, there should be a distinction between what is a civil violation and a criminal violation. One of the key issues in this area, currently up before the Supreme Court in a case called Van Buren, is whether or not that violations of, well, in that case, some use policies, another common case is terms of use in EULAs. If you violate them, are you doing unauthorized access and therefore illegally hacking for violating someone's terms, which ordinarily violating a contract is a civil matter. So yeah, you should have criminal intent. You should, before you can be criminally prosecuted, if someone is doing good faith research, that shouldn't be a crime. And the other thing is that many of these penalties are completely out of whack with what is a penalty for something does a similar amount of harm in real life. That, computer trespass versus physical trespass, widely disparate forms of harm. So there's a lot of things in real life where there may be a law that prevents it and you're criminal for doing it, but you're talking about 30 days and small fine. Mostly first offenders won't get jail time. And then if you do something which sort of creates a similar amount of harm, but you're using a computer and you're doing it online, you're looking at 5 years, and it's just a way out of whack. And we're trying to keep those things for not over criminalizing hacking laws. So some practical protections to think about if you're doing vulnerability research. One is you don't want to be a test case. So this is where if there's an uncertainty around the law, you should know it, be cautious about being the one to establish a test case. Nevertheless, improving security is vital work. It's something that is worth doing. So how do you do that? Well, try and reduce your risk with best practices. Now, unfortunately, not all vendors are ready for vulnerability disclosure. So a lot of this talk is going to be focusing on vulnerability disclosures in a situation where they don't have a bug bounty program. They don't have a structured thing. They haven't gone through and adopted the disclose.io you just heard about, safe harbor provisions, but instead you're encountering somebody in the wild. So what is this talk? What isn't this talk? Well, I'm not trying to give a morality tale or a formulaic approach to disclosure. And one thing, sir, this is definitely not legal advice. EFF does give legal advice, but we're giving the legal advice that is a one-on-one conversation protected by the privilege, not a presentation to the world. So you're starting some security research. What can you do to be better positioned so you can disclose that later? Well, a couple of things to get ahead of the game before you're starting research. Do it on your own equipment, accounts, networks. One of the key aspects of anti-hacking laws are unauthorized access. So if you're hacking on your own machine, you authorized it. You are the one who owns it. You can authorize it. You can avoid a lot of CFAA problems by working on your own equipment. Then, if you're working with somebody else's equipment or service or online service, do you have to agree to their terms of service or their end user license agreement? For example, if you buy something used, you can often get it without having to go through a step where you're agreeing to a terms of service or a EULA. And some of the problems you may occur in finding a vulnerability, if you had to sign up for a service, you had to agree to a license agreement, that gives a angry vendor an avenue of attack to say that you breached that EULA, you breached that contract, and therefore they have some angles to attack you. Also, look for bug bounty programs. Say like if there is one, this often gives you what the terms are, how it's going to be. Very valuable information to know beforehand. For example, they might say, totally go ahead and do some research on us, but create a special account to just do it on that account instead of doing it on a regular account. So, I mean, that is something that you can do before doing the research and save yourself some trouble later. Also, consider the optics. Consider how it's going to look both to the other side and, if necessary, to a prosecutor or a court. Are you going to look like you're a bad actor, or are you going to look like you're a good faith researcher? And while there is a lot of room in the law for things where you might say that, well, technically, this may be a problem, but don't worry about it. That's prosecutorial discretion is going to determine whether they don't worry about it. And so if the prosecutors think you're acting in good faith, they may use that discretion to not prosecute. And if they think you're acting in bad faith, they may use that discretion to start prosecuting. So you find a vulnerability in someone's project. What do you do? Well, first of all, think about what your goals are. What are you trying to do? Are you trying to just fix all the things? You want to find vulnerabilities and get them to be fixed? Do you want to publish and present about it? Do you want to have a talk at a hacker conference like this one, at DEF CON, at Black Hat, maybe get famous, enhance your career because you're known to have successfully done a great hack? Do you want to get paid? Through a bug bounty program, through other means, you want to be able to make this a career. After you figured out your goals, think about a couple of things. So I think Casey actually just hit it upon in the last talk. So I think they're actually good. We have these back to back, but remember that the developers you're talking to are people too. So the computers are machines, software runs on those machines, but the people you're talking to are people. And you're telling them that they made a mistake. They screwed something up. There's a vulnerability in the code that they have made that they need to fix. And so it's inherently something where you want to be sort of sensitive to the human aspect of the person on the other side and hopefully get into a mode where you're working together to fix a problem and they're understanding about how problems happen. But in your interactions with them, if you understand that they're people and react to them like they're people, that will help smooth the path. Also, do your homework. Try and get a little bit more information before you move forward with a disclosure. There's a lot of ways to do that. Like, do they have a submission process to present them with vulnerabilities? So, for example, the disclose.io has a list of many vulnerability disclosure programs and bug bounty programs. Check that out. Other sources, you might, just do Google searches or DuckDuckGo searches to figure out what they have already and what they say about it. Also take a look at some other things, like what is the company's history? Do they have a history of going after security researchers? Or have they never interacted with a security researcher? One of the areas where we have found sort of the most difficulties in vulnerability disclosures are when talking with an industry that is encountering security researchers for the first time. So their CEO said, hey, we need all the toasters to have IP addresses. And they're like, great, we will make internet-enabled toasters. But they, prior to that, have just made regular toasters. And they really have no idea what the security community is or how that somebody might actually take apart their toaster, figure out how it can be remotely controlled to set a house on fire, and then someone tells them that and they freak out. This is one of the challenges, because more and more things are getting internet enabled. Internet of Things has a lot of players that don't have prior experience dealing with the possibility that someone might point out a flaw publicly about their product, and they're really worried about it. So in that case, might be proceed with a little bit more caution. The other thing, you want to find a person to disclose to. So ideally, the person who developed it, someone who really understands it, or maybe the company has a team, a security team, or some other team that responsibility includes security. Getting it to the right person who knows what's going on will be very helpful. If it goes to other teams like the legal team or the PR team, then it's more likely to be looked at through a lens of, are we legally liable? Is this going to be a problem for us legally? Or is this going to be a problem for our public relations? And that can create more tension and difficulty than if you're just talking to the actual coders who worked on the project managers who understand it, can hear what you're saying, and work to deal with it. So ideally, you don't want to just email customer service at the company's name. But sometimes you get stuck. You can't find those things. So this is a great opportunity to try and reach out, to some of your friends in the security community. Do they know somebody there? A friend of a friend can pass along a message, can try and set up a conversation. And if someone, don't know them directly, or you don't know who might know them, LinkedIn can actually be a very useful thing. Search for the company's name on LinkedIn, try and scan through that, or search through that to find people with security in their title. And maybe LinkedIn has a feature where you can sort of find out if you have connections. So that may be a way of reaching, or you can just reach out directly through LinkedIn. So only as a last resort do you want to use sort of generic contact points, like filling out a customer service online form, or emailing to a generic email address. It is a way of contacting them, but it's not a highly effective way of contacting. So once you contact them, you want to make a good first impression. The first that you're hearing from you is setting the stage for how they will be thinking about you for the rest of the interaction. And so you want to come across in a way that is friendly, that is helpful, that is going to not exacerbate tensions, but reduce tensions. So how important is the issue you discovered? If you discovered something that is it like a minor issue, or does it have incredible public safety effects? Is it going to be a big deal or a small deal? Like, so for example, you found a vulnerability in a heart implant. Somebody could die as a result of this. That sounds like it's more of a big deal. Or maybe you found a vulnerability in a game console that would allow someone to cheat in a game. Okay, a medium deal. Some people would care about that, but not quite at the level of somebody dying. And don't oversell it or undersell it. So if you oversell it, that may cause people to freak out. And then if they later found out that it's not as bad as you had said, it creates some mistrust. If you undersell it, maybe they won't take it seriously and they won't try to fix it. So try and be just as straightforward as possible about what it is and what some of the ramifications are. Now, you still may get some resistance. So somebody who has made a heart implant that has a security vulnerability, it's very hard to fix that. Maybe their firmware is require surgery to change. So they might be in denial and not want to hear there's a problem. But still, you're identifying it, you're being straightforward about it. Don't threaten. So be careful not to have it come across that like the disclosure is a threat. If you don't fix this, I'm going to do this bad thing that's going to harm you by disclosing it to the world and give you bad PR. That sets a bad tone. It's more about, you want to do good for the world. You want to disclose it to make the world a better place. And you want to give them a heads up about it to try and get it fixed ahead of time. Friendly tone, not a threatening one. And also, like, don't make demands on or ultimatums. Oftentimes that can lead in a very dangerous direction. So, for example, sometimes it comes up where people are thinking, I can get paid for this. This would be great, but they don't have a bug bounty program. Well, that can be dangerous, because if you say, I'm going to disclose this to you, but you first have to pay me, or bad things are going to happen or people are exploiting it, some people might interpret that as extortion. They might think that they're being shaken down, and then route this, instead of through a security team trying to fix the problem, to a legal team. They may reach out to prosecutors. That can go in a bad direction. Now, the other thing some people want to do is they can help, right? You understand the problem, you identify the problem, maybe you could help fix it. And of course, you value your time. It's fair to get paid for that work. But if you make it so that like it's contingent on you getting paid, that raises some of these same kind of like, is that a threat? Is that an extortion issues? Another thing is offering to keep quiet in exchange for something, for the money or otherwise. Again, this has been led to the sort of the notion of like, you are saying, unless you pay me, I'm going to say this bad thing about you, and that can lead to a notion of extortion. And also, if you end up signing an NDA or offering to keep quiet, if your plan is to ultimately disclose, to give a talk about it, to use this to enhance your reputation, your career, if you sign something that says you have to keep quiet about it, that really can mess up your plans to use it later, to go ahead and talk about it. So, think about that. There may be times where it is fine to agree that you won't disclose it for a period of time while they fix it. That is often the case in vulnerability disclosures, but for a forever ban may be very limiting, and you'll be regretting it later. And don't say too much too soon. So, especially if you found something like, the crown jewels, you've hacked into KFC and you found their secret herbs and spices. If it happens like in the first conversation, it can really set a bad tone because they could cause some fear or panic on the other side. So, you might want to establish some communications and trust and before sort of revealing how bad it was. And having the relationship first, establishing it, and then escalating to what the situation is can be an easier way for the other side to take it. Now, some of these processes, you might want to contact a lawyer, and that's one of the things that the Coders Rights Project offers. You can reach out to us, and we can either try and help you as lawyers or refer you to lawyers. So there are many things that could come up where you probably would want to speak to a lawyer before disclosing. So if you broke a DRM, then the Section 1201 of the Digital Millennium Copyright Act has some rules that say basically if you break something that protects the copyrighted works, then that can be a violation of the DMCA. You can be held liable, potentially criminally in some cases. There's a lot of noise around that in terms of when some exceptions apply. But that's something that you'd want to talk through with a lawyer. Or if you violated an NDA. So if you at some point had agreed to an NDA and discovered the vulnerability in that process, well, then that may be something you want to talk to a lawyer about before going out with disclosure. If you click through a license, if you signed a EULA or a TOS, again, that's something that you might want to think about while talking through a lawyer. And you may also want to think of, what is your sources? If you got something through a source that may be suspicious or a little weird or shady, you want to think about talking to a lawyer under those circumstances. And another one very commonly comes up is perhaps everything that we find for the research, but you may actually face some blowback from your lawyers. Perhaps this is a client or a client that they want to have, even if they don't have yet, and your employer may have some issues for you if you go ahead and do disclosure. It may be, did you learn some of the things on the job? How do you show that it was separate from your employment work? So these are circumstances that you might want to check it out with a lawyer. So for all of this, we're giving some broad overviews here, but keep in mind that like it's not a formula. It's not that one way of disclosure is always the best. And there are many legal issues that can get in trouble. But I think that for a lot of the cases, these can be dealt with. And this is also one of the reasons why it is so important and hopefully a very growing phenomenon for companies to try and avoid some of these legal issues by helping out the security researchers and having a good program for vulnerability disclosures that addresses it on the front end. So on getting paid, well, the easiest way is if they already have a bug bounty program. Then you can just submit pursuant to the program. Check out if the terms fit with what you're doing and work through it. If they don't have one, probably it's not going to happen. And trying to ask to get one raises some of those extortion issues. But if they go ahead and do that, great. But don't get your hopes up. So don't demand the money if they don't offer it. Another ways of disclosures. So this is an example of somebody who found a vulnerability that would allow someone to post on Mark Zuckerberg's page, or anybody's page really, and disclosed it by posting on the page. So like sort of demonstrating your flaw in a sort of flamboyant manner can create some difficulties with the follow-on conversations. Okay, so you've done your thing, trying to disclose it. Now, what do you do when you do a talk? And you have to figure out for that, do you want to disclose privately first? We talked a lot about disclosing privately, but it's actually a decision if you're going to be presenting about it. In some cases, in most cases, perhaps, you want to disclose it privately to the company to give them a chance to fix it first. But that is a decision to make depending on the severity of it, the fixability of it, something you have to think about. So what's the advantage of disclosing first? Well, they can fix it. It can make the world a better place. But the flip side of that is they know that you're about to do the presentation. That gives them an opportunity to try to stop that presentation, to threaten you with a lawsuit, to even file a lawsuit, to muddy the waters to make it more difficult to present. And then there's issues about timing. If your presentation has a fixed time period, the conference that you want to present at is in 90 days, and they say, well, we need 120 days to fix this, then that may be a tension between you and the vendor for the timing. So consider whether you want to do that. And oftentimes you can work that out with them, especially for companies who have some familiarity with security research, understand about hacker conferences and presentations, and gives them an incentive to do it. Because ultimately, people win the most on these presentations if you can do the presentations, talk about how the problem has been fixed, maybe even have a representative from the company at the conference to talk about what they fixed, and show how security researchers and vendors can work together to solve problems. That can be a win for everybody. So when you're doing a presentation, you may want to promote it, and many people do. It's important to how you present it, how much attention you're bringing to it before the talk. So if you're promoting the talk, but you haven't talked to somebody first, that may be how they first hear about it. And there's sometimes a communication issue that can occur between vendors and the security research community, because vendors, they're worried about bad press. They're worried their product won't sell as much. Can be very tense about this. And in many cases, to bring attention to a talk, there are some provocative or snarky titles or abstracts, pointing out how this vulnerability could lead to all sorts of problems. An example of this was a talk that we helped out people with a long time ago. It was entitled "Free Subway Rides for Life." And it was about some flaws in the Massachusetts Transit Authority's fare payment system. And it was a very provocative title. And people could, presumably go to this talk and learn how to get free subway rides for time. Now, the truth was that it was an important vulnerability, but it wasn't an instruction manual. It was just a way of saying, in the language of the security research community, that this is a serious problem that needs to be addressed because you don't want to give people free subway rides for life. Not, we want to show this, but rather we want to prevent this. But it was interpreted, at least initially, by the Transit Authority as this is a how-to session to get people to be riding their transit system for free. And so that communication failure ended up causing some problems that ultimately were resolved, but it was very difficult for a period of time, and ultimately the talk had to be taken off the schedule. So think about that when you're trying to bring attention to it. Bringing attention in a way that is going to be most productive to bring attention to the important issue, but think about also how the person on the other side, the coder, the developer who's made it, is going to react to that attention. Yeah, there we go. I should have had that slide up, but that's the thing. What are you doing with the talk? How provocative it should be? So, proof of concept, very useful things to show how it's not just a theoretical vulnerability, but it actually is a working vulnerability. And that is something, to show someone with good technical ability to understand what it is. So proof of concept, very, very valuable things. But they're dual use. A proof of concept could also be used, or maybe with some modifications and adjustments be used to be able to execute and exploit the vulnerabilities. So most likely, the more likely the audience is to use the information to break the law, the more risk there is. So if this is something that a proof of concept that any script kiddie could download and start exploiting a vulnerability right away, that is going to raise the tensions. If you're putting out a proof of concept that is mostly going to be used by high-level people who are in the field to understand the problem, but would be hard to use to actually exploit, or maybe it's a proof of concept for a problem that has since been fixed, great, that's not going to have the same kind of tensions and problems. So don't do it so that the script kiddies can just sort of run away with it. There are better ways of advancing the art. You can also do live demos. An example, of course, live demos often can be troublesome when you're in a presentation, so you might actually want to make a recording of a demo, but you can show how an exploit works without giving away all the secret sauce of how it works. So to sort of start to wrap it up, I want to point to a couple of resources that people can use. So one is the Coders Rights Project itself, EFF.org/coders. And you can go there, you can get some overviews of some of the legal issues that may face, contact points for us. For a more in-depth guide about some of the legal risks that you may face, we worked with the clinic, the cyber clinic at Harvard, to produce a guide for legal issues for security researchers. So there's a link to this at the clinic.cyberharvard.edu. And then if you find yourself in a situation where you might be needing some legal advice on this, you want to talk to a lawyer, reach out at info@EFF.org. And then we try to help as many people as we can, but if we can't help you directly, try and provide a referral. EFF's legal services are free, so don't worry about the cost of it. And sometimes we're able to refer to people to other pro bono attorneys, other times low-cost attorneys, but we try and find a situation where people can get some advice. And earlier on in the process, we can advise both on the research stage and the disclosure stage. Can often be just a way to avoid a lot of future problems. But also, we've talked to people the day before their talk was about to be given. So, don't ever think that it's too late to reach out if you have a legal question or you're worried about how this will go. So with that, I want to say thank you to everybody for having me on here. And I'm ready to take questions, which I understand will be on the Discord server.
Yes, sir. And thank you again, Kurt. I really appreciate your time and supporting the community, supporting actually not only here, but through the EFF, for many, many years. So thank you so much. And as Kurt mentioned, we're going to be actually handling some of the questions through the Discord server. The information is in the bottom of the screen. We're going to go in a quick break until the next presenter comes in. And once again, Kurt, I really appreciate it. Thank you.
Thank you for having me.